Hi everyone and welcome back to the official channel of LegalEdge. Now let's start with our session. तो अब आज हम क्या करने वाले हैं? So when it comes to the entrance examination of National Law University उड़ीसा, उड़ीसा में लीगल रीजनिंग से रिलेटेड कुछ ना कुछ क्वेश्चंस हमें हमारे पेपर में देखने के लिए मिलते हैं. And the primary pattern of the questions under your or in your NLUO examination is, in a way, it is heavily based on the legal GK, which will include constitution related questions and with respect to legal terms and maxims as well. ठीक है. So heavily हमारे questions जो हमारे पेपर में है ना, they are related to Constitution of India only and they are in a way related to legal terms and maxims as well. But at the same point of time, we can also expect them to be asking certain principle fact based questions as well, wherein you have to make the application or you have to apply the legal principle which is given over there over a given factual situation and come to a conclusion. ठीक है. So आज हम क्या करेंगे? आज हम इन दोनों ही पैटर्न ऑफ क्वेश्चंस को सॉल्व करेंगे. ठीक है. We'll be solving both the pattern of questions over here. चलो. So let's start with our session and let's look at the first question. So the first question is that which act introduced for the first time the concept of a federal structure in India by establishing a government of India with Federation of British India and the princely states? किस एक्ट के थ्रू फेडरेशन ऑफ इंडिया एस्टैब्लिश करने की बात की गई थी? So the act through which Federation of India was actually introduced was the Government of India Act 1935. ठीक है. So the correct answer in question number 1 is option C, that is the Government of India Act 1935. ठीक है. चलो अब इस तरीके के टॉपिक से क्वेश्चंस को क्यों पढ़ के रख लेना, क्योंकि देखो पुराने पेपर्स के एनालिसिस के बेसिस पे एक चीज रियलाइज हुई है कि कॉन्स्टिट्यूशन ऑफ इंडिया के हिस्टोरिकल बैकग्राउंड से रिलेटेड क्वेश्चंस हमें देखने के लिए मिलते हैं. ठीक है. एंड देयरफॉर कवरिंग द टॉपिक्स ऑफ हिस्टोरिकल बैकग्राउंड ऑफ द कॉन्स्टिट्यूशन बिकम्स इंपॉर्टेंट थिंग. ठीक. So the correct answer in question number 1 was option C. Chali. Let's move to the next one. Now, the next question is, who was the president of the Constituent Assembly of India that drafted and adopted the Indian Constitution? Constituent Assembly का president कौन था जिस असेंबली ने हमारे इंडियन कॉन्स्टिट्यूशन को ड्राफ्ट और अडॉप्ट किया था? ए जवाहरलाल नेहरू, बी बी आर अम्बेडकर, सी राजेंद्र प्रसाद एंड डी वल्लभ भाई पटेल. So what's the correct answer in question number 2? Correct. The correct answer is that the president of the Constituent Assembly was Dr. Rajendra Prasad. देखो, B.R. Ambedkar was the chairman of the drafting committee. ठीक है. B.R. Ambedkar was the chairman of drafting committee. Constituent Assembly के अगर हम president की बात करते हैं, so the president of the Constituent Assembly was Dr. Rajendra Prasad. ठीक है. चलिए, let's move to the next one. Now, the next question is, which of the following constitutional developments first granted Indians direct association with legislative functions at the central level? So the question is primarily trying to ask us कि किस एक्ट के थ्रू इंडियंस को इंट्रोड्यूस किया गया था with respect to the legislative bodies at the central level. A. Indian Councils Act of 1861, B. Indian Councils Act of 1892, C. Indian Councils Act of 1909 and D. The Government of India Act 1919. तो पहले एक्ट की बात करें ना जिसके थ्रू इंडियंस को इंट्रोड्यूस किया गया था टुवर्ड्स द लेजिस्लेटिव बॉडीज, दैट एक्ट वाज द इंडियन काउंसिल्स एक्ट ऑफ 1861. ठीक है. इस एक्ट के थ्रू 3 इंडियंस were nominated to the legislative council of the viceroy. ठीक है. इस एक्ट के थ्रू 3 इंडियंस को नॉमिनेट किया गया था to the legislative council of the viceroy and the 3 Indians included Raja of Banaras, Maharaja of Patiala and Sir Dinkar Rao. Okay? These were the three Indians who were nominated as non-official members of the Legislative Council of the Viceroy. Okay? So the correct answer in question number 3 was option A. Chal. Let's move to the next one. Now, the next question is, what was the primary constitutional significance of the Objectives Resolution moved by Jawaharlal Nehru in the Constituent Assembly in 1946? ठीक है, तो पंडित जवाहरलाल नेहरू ने 13 दिसंबर 1946 को कॉन्स्टिट्यूएंट असेंबली में एक रेजोल्यूशन मूव किया था जिसका नाम था ऑब्जेक्टिव रेजोल्यूशन. ऑब्जेक्टिव रेजोल्यूशन का सिग्निफिकेंस क्या था? A, it formally declared India's independence from the British rule in December 1946. B, it laid down the fundamental principles and philosophies that guided the drafting of the constitution. C, it established a drafting committee under B.R. Ambedkar for preparing the constitution. And D, it determined the constitutional or the territorial boundaries of the newly independent Indian Union. तो ऑब्जेक्टिव रेजोल्यूशन का प्राइमरी पर्पस था टू ले डाउन द ऑब्जेक्टिव्स ऑफ द कॉन्स्टिट्यूएंट असेंबली. ये कॉन्स्टिट्यूएंट असेंबली क्यों वहां पर मिली है, क्या वो काम करना चाह रही है, व्हाट काइंड ऑफ कॉन्स्टिट्यूशन दे वांट टू इनैक्ट एंड गिव टू द पीपल ऑफ दिस कंट्री. And therefore, the correct answer was that the constitutional significance of the objective resolution was that it laid down the fundamental principles and philosophies that guided the drafting of the constitution. Okay? So the correct answer in question number 4 was option B. Chal. Let's move to the next one. Now, the next question or the next important thing or the area from where you can expect the constitution is with respect to the sources and मेकिंग ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. ठीक है, कॉन्स्टिट्यूशन ऑफ इंडिया के अलग अलग सोर्सेस और उसकी मेकिंग से रिलेटेड भी आप प्रोविजंस या आप अपने क्वेश्चंस एक्सपेक्ट कर सकते हो. सो द क्वेश्चन इज, फ्रॉम विच कंट्रीज कॉन्स्टिट्यूशन डिड इंडिया प्राइमरली बोरो द कॉन्सेप्ट ऑफ फंडामेंटल राइट्स एंड द प्रोविजंस फॉर जुडिशियल रिव्यू. फंडामेंटल राइट्स एंड जुडिशियल रिव्यू को किस कंट्री के कॉन्स्टिट्यूशन से इंस्पायर होकर ऐड किया गया था? ए, यूनाइटेड किंगडम, B, Ireland, C, United States of America, and D, Australia. What's the correct answer? क्या correct answer है भाई? Correct. The correct answer in question number 5 is that these two provisions were actually taken from the Constitution of United States of America. ठीक है? So the correct answer was option C. चल. Let's move to the next question. Now, the next question is, which country's constitution served as the primary source for directive principles of the state policy incorporated in part 4 of the Indian Constitution? Indian Constitution के part 4 में वो जो DPSP added है, directive principles of the state policy, उस चीज की इंस्पिरेशन कहां से ली गई थी? A, कनाडा, B, साउथ अफ्रीका, C, सोवियत यूनियन एंड D, आयरलैंड. कहां से इंस्पिरेशन ली थी भाई हमने डायरेक्टिव प्रिंसिपल्स ऑफ द स्टेट पॉलिसी के लिए? So the inspiration for part 4 of the constitution was taken from the Irish constitution. Okay? So the correct answer in question number 6 was option D. Okay? Let's move to the next one. Now, the next question is, which of the following correctly identifies the source from which the Indian constitution borrowed the emergency provisions that allowed the center to assume extraordinary powers? Which of the following correctly identifies source from which the Indian Constitution borrowed the emergency provisions that allowed center to assume extraordinary power? A, the Constitution of the United States of America. B, the Government of India Act 1935. C, the Constitution of Australia. And D, the Constitution of Canada. यहां पे जो करेक्ट आंसर है ना, देखो इस चीज के लिए इंस्पिरेशन हमने जर्मन कॉन्स्टिट्यूशन से भी ली. But at the same point of time, similar type of analogous provisions were actually given under the Government of India Act 1935 as well. ठीक है? So correct options जो हमारे पास यहाँ given थे, उसमें the correct answer will be option B. That is, it is the Government of India Act 1935. ठीक है? चलिए, let's move to the next question. Now, the next kind of an important topic from where you can expect the questions in your paper is your fundamental rights. Okay, you expect certain number of questions from part of fundamental rights as well. So let's look at the questions. Which article of the Indian Constitution prohibits the state from discriminating against citizens on the grounds only of religion, race, caste, sex or place of birth? ठीक है, कौन सा आर्टिकल स्टेट को प्रोहिबिट करता है? That state shall not discriminate among the citizens on these grounds of religion, race, caste, sex or place of birth. So the correct answer over here is Article 15, which deals with prohibition on discrimination. Okay. Article 16 in a way deals with equality of opportunity in matters of public employment. 14 is about equality before law and equal protection of law, and 17 is about abolition of untouchability. Okay. So the correct answer in question number 8 was option A, that is, it is Article 15, which prohibits the state from discriminating among the citizens on the basis of religion, race, caste, sex or place of birth. Check. Chal. Let's move to the next one. The next question is, under Article 19 Clause 1 of the Indian Constitution, which of the following is not one of the 6 freedoms guaranteed to the citizens? Under Article 19 Clause 1 of the Indian Constitution, which of the following is not one of the 6 freedoms guaranteed to the citizen? A. Freedom of speech and expression. This is given under Article 19(1)(a). Freedom to reside and settle in any part of India. This is something which is given under Article 19(1)(e). Freedom to move freely throughout the territory of India. This is given under Article 19(1)(d). And freedom to acquire, hold and dispose of property. Initially, it was one of the fundamental freedoms of Article 19 Clause 1. But this is no more a fundamental right, and therefore the correct answer over here was option C. That is, freedom to acquire, hold and dispose of property is not one of the 6 freedoms guaranteed to the citizens. Okay, chalo. Let's move to the next one. Now, what is the scope of protection against self-incrimination under Article 20 Clause 3 of the Indian Constitution? Protection from self-incrimination, which is given under Article 20 Clause 3. So, what's the correct answer? A says no person accused of any offense shall be compelled to be a witness against themselves. B says no person shall be convicted for the same offense more than once. C says no person shall be subject to a penalty greater than that might be prescribed at the time of commission of the offense. And D says no person shall be arrested without written warrant issued by a competent magistrate. Article 20 Clause 3 basically gives us the protection which is given under option A, that no person accused of any offense shall be compelled to be a witness against himself. This is the scope of protection against self-incrimination given to us by Article 20 Clause 3. Okay? Clear? Chaliye bhai. Let's move to the next one. Now, another kind of important portion from where you can expect the questions is from the part of judiciary and judicial officers. ठीक है, यहां से भी आप क्वेश्चंस एक्सपेक्ट कर सकते हो in the paper. So the first question is, under which article does the Supreme Court of India exercise its advisory jurisdiction to give opinions to the President of India? ठीक है, जिसको हम presidential reference भी कहते हैं, wherein the President is authorized to seek the opinion of the Supreme Court on any matter of public importance. ठीक है, A. Article 141, B. Article 139, C. Article 145 and D. Article 143. So presidential reference or advisory jurisdiction is something which is given under Article 143 of the Constitution of India. Okay? So the correct answer over here was option D, that is Article 143. Okay? Chalo. Let's move to the next one. Now, the question is, which of the following correctly states the original jurisdiction of the Supreme Court under Article 32 that makes it unique compared to the High Courts? Which of the following correctly states the original jurisdiction of the Supreme Court under Article 32 that makes it unique compared to the High Courts? Article 32 allows the Supreme Court to hear appeals from all the High Courts. Article 32 itself is a fundamental right and cannot be suspended except under Article 359. Article 32 gives the Supreme Court power to punish for its contempt of all subordinate courts, and Article 32 allows the Supreme Court to review legislative acts of the Parliament only. Now, this is not correct because it is not the appellate matter of the Supreme Court. C is saying punish for the contempt of subordinate courts. This is also not the subject matter of Article 32. Article 32 allows only the Supreme Court or the Supreme Court to review legislative acts of the Parliament only. This is also not correct. So, if the legislative act of a state legislature is violating the fundamental rights of the people, the court can hear the matter under Article 32 for those cases as well. And therefore, D was also not the correct answer. And the correct answer over here was option B, that Article 32 itself is a fundamental right and cannot be suspended except under Article 359 of the Constitution. Okay? So, the correct answer was option B. Chalo. Let's move to the next question. Now, the next question is, how many judges constitute the quorum for Supreme Court to declare a central or a state law unconstitutional under Article 145 Clause 3? How many judges constitute the quorum for the Supreme Court to declare the central or the state law as unconstitutional under Article 145 Clause 3? A, minimum bench of 3 judges, minimum bench of 5 judges, full bench of all the judges of the Supreme Court, and minimum bench of 7 judges. So, in constitutional matters, what is required is a minimum bench of 5 judges of the Supreme Court. Okay. So, the correct answer over here was option B. Chalo. Let's move to the next one. Now, the next question is related to the powers of the High Court. Okay. Now, the question is, under which article of the Indian Constitution does a High Court have the power of superintendence over all subordinate courts and tribunals within its jurisdiction? किस आर्टिकल के हिसाब से the High Court will have the power of superintendence over all the subordinate courts which are located in that state or in that territory? A, Article 215, B, Article 226, C, Article 227, and D, Article 229. So the correct answer over here is the power of superintendence over all the subordinate courts or tribunal within the territorial jurisdiction is given to the High Court under Article 227 of the Constitution of India. ठीक है, कि उस स्टेट में उस टेरिटरी में जितने भी सबऑर्डिनेट कोर्ट्स या ट्राइब्यूनल्स हैं उन सब के ऊपर हाई कोर्ट वहां पर पावर एक्सरसाइज कर सकता है, सुपरिटेंडेंट एक्सरसाइज करे. ठीक है, चल लेट्स मूव टू द नेक्स्ट वन. नाउ द नेक्स्ट क्वेश्चन इज which of the following correctly states the grounds on which a high court judge can be removed from the office? ठीक है, करंट अफेयर्स में भी पार्ट था बिकॉज ऑफ द कंट्रोवर्सी रिलेटेड टू जस्टिस वर्मा केस, है ना, ये सब तो आपने सुना ही होगा, राइट? अब किन ग्राउंड्स पे जज को, हाई कोर्ट जज को रिमूव किया जा सकता है? रिमूवल बाय द गवर्नर ऑफ अ स्टेट ऑन रिकमेंडेशन ऑफ द स्टेट कैबिनेट, रिमूवल बाय द प्रेसिडेंट ऑन एड्रेस ऑफ बोथ हाउसेस ऑफ द पार्लियामेंट बाय स्पेशल मेजॉरिटी, removal by the Chief Justice of India on grounds of professional misconduct, and removal by the Supreme Court on a reference made by the President of India. So the correct way of removing a judge of a High Court is option B, removal by the President on address of both houses of the Parliament by special majority. Okay? So the correct answer in question number 15 was option B. चल आगे बढ़ते हैं. Now the next question is, what is the retirement age of High Court judge under Article 217 of the Indian Constitution? What is the retirement age of a High Court judge under Article 217 of the Indian Constitution? A 60 years, B 62 years, C 65 years और D 68 years. तो हाई कोर्ट जजेस की अगर हम रिटायरमेंट एज की बात करें तो दैट इज 62 years, है ना. 65 years is given in case of Supreme Court judges. I'm so sorry. 65 years is the retirement age of the judges of the Supreme Court. High Court के judges की retirement age है आपकी 62 years. ठीक है, चल let's move to the next one. Now another important portion from where you can expect the questions that I initially told you guys as well, that is related to Latin maxims and legal terms. This is also one of the expected portion of your paper जहां से आप questions को expect कर सकते हैं. Okay. So the first one is question number 17 is, what does the Latin maxim actus non facitrium nisi mens iteria mean in the context of the criminal law? What does the Latin maxim actus non facitrium nisi mens iteria mean in the context of criminal law? A. An act is criminal only if it is committed in public space, public place against society. B. An act does not make a person guilty unless the mind is also guilty. C. A criminal act once proven shifts the burden of proof to the accused entirely. And D. No person can be punished without a written charge being formally filed in the court. So, जो correct answer है यहाँ पर, ठीक है? If we look at the correct answer, the meaning of actus non facitrium nisi mens iteria is that an act is not guilty unless it is accompanied with a guilty mind. And that is the concept of actus reus and mens rea under our criminal law. Enough? So the correct answer over here was option B, that an act does not make a person guilty unless the mind is also guilty. Okay? Chal. Let's move to the next question. The next question is, what is the correct meaning of the Latin term obiter dictum in judicial decisions? What is the correct meaning of the Latin term obiter dictum in judicial decisions? A. The binding part of a judgment that must be followed by all lower courts. B. An observation made by a judge in passing that is not essential to the decision. C. A judgment delivered by the majority of judges on a constitutional bench. And D. A written dissent by a minority judge disagreeing with the majority opinion. So what is the meaning of obiter dictum? See, there are two parts of the judgment. One is known as a ratio. The other one is known as obiter. Now, ratio is binding part of the judgment. And obiter is actually passing remarks. Any kind of an observation made by the judge which is not an operative part of the judgment, usko obiter dictum kaha jata. And therefore the correct answer was option B, that an observation made by a judge in passing that is not essential to the decision. That is the correct meaning of your term obiter dictum. Okay, chal. Let's move to the next question. Now, the next question is, what is the correct meaning of the Latin phrase locus standi as used in judicial proceedings? What is the correct meaning of the term locus standi as used in judicial proceedings? A. The physical location where a court hearing must mandatorily be conducted. B. The right or capacity of a party to bring an action or appear before a court. C. The standing order of a court directing parties to maintain status quo. And D. The position of a judge in the court hierarchy to hear a particular case. Now, when it comes to the correct meaning of locus standi, it's basically a right of the person to be heard by the court. That is what locus standi is. And therefore, the correct answer in question number 19 was option B, that the right or capacity of a party to bring an action or appear before a court is what locus standi is. Okay? So, the correct answer in question number 19 was option B. Chalo. Let's move to the next one. Now, the next question is, what is the correct meaning of the term sub judice as commonly used in legal and legislative proceedings in India? What is the correct meaning of the term sub judice as commonly used in legal and legislative proceedings in India? A. A matter that has been finally decided and disposed of by a competent court. B. A matter that relates to a judge's personal conduct under inquiry. C. A matter that is outside the jurisdiction of any court in the country. And D. A matter that is under active consideration or pending before a court of law. So what is the meaning of sub judice? Sub judice basically means something which is pending before a court or pending before an authority. So when we say a matter is sub judice in the court, that means the matter is still ongoing in the court. No final verdict has been delivered yet. The matter is still pending. And therefore the correct answer in question number 20 was option D, that is a matter that is under the active consideration or pending before a court of law is what sub judice is. Okay? So the correct answer in question number 20 was option D. Chal. Let's move to the principle and fact-based question. So the question is in front of you and start solving it, guys. हाँ जी, डन, ठीक है। चलो देखो, प्रिंसिपल क्या था हमारे पास, द प्रिंसिपल वॉज letters or words not describing the quality of things can be registered as a trademark. So any kind of a letter or any kind of a word which is actually not describing the quality, it is not telling us anything about the product or the quality of the product. These kind of descriptions can be registered as a trademark. Okay, this was the principle. Facts are, Ria made an application for registration of the alphabet Z written in a unique artistic style as a trademark to be used on packets and boxes of homemade chocolates manufactured by her. Now, can this Z be registered as a trademark? Now, is it telling anything to us about the quality of the product? Anything about the product? No, right? And therefore, it can be registered. And therefore, the correct answer over here was that option C. The alphabet Z can be registered as a trademark because it does not describe the quality of the goods and is used in a distinctive style. Okay? So the correct answer in question number 21 was option C. Chal. Let's move to the next one. Solve the next question, guys. Yeah. So are we done? Done? Everyone? Sure. Dekho. Principle was basically related to one of the concepts of our law of torts, which is known as injuria sine damnum. Okay, principle was related to one of the concept of our static laws or the law of torts, which is known as injuria sine damnum. Injuria sine damnum basically refers to those situations where there is a violation of legal right, but without any loss or harm. So principle says that in cases where there is an infringement of a legal right, even without any actual loss or damage, the person whose right is infringed has a cause of action. That is, the person whose legal right is violated over there has a right to file a case against the other party. Okay? Now, the facts are, A is a member of a premium co-working space and has a valid access card, allowing him to use the conference room between 5 and 6 p.m. One day, when A reaches the co-working space at 5 a.m., the manager B refuses to allow him to enter the conference room without any valid reason. A suffers no financial loss because he conducts the meeting online from another room, but he sues B for violation of legal rights to use the conference room. Can he sue the other person? So the answer is yes. There is no loss or there is no harm because he conducted the meeting from another room. So there was no actual damage or harm which took place, but his legal right was violated now because he had the access card and had the permission to use the room between 5 to 6 p.m. And therefore, the correct answer in question number 22 was option B, that A can sue because his legal right was infringed even though no actual damage was suffered. Okay. So the correct answer in question number 22 was option B. Chalo. Let's move to the next one. Solve the next question, guys. Yeah. So are we done with question number 23? Done? Sure. देखो principle क्या था? The communication of proposal is complete when it comes to the knowledge of the person to whom it is made. Proposal या offer का communication कब complete माना जाता है under the contract law? So the communication of offer or proposal is considered as complete when it comes into the knowledge of the person to whom it is made. जिसको आपने ऑफर भेजा है उसकी नॉलेज में जैसे वो ऑफर आ जाए तब उस ऑफर का कम्युनिकेशन को कंप्लीट माना जाता है. ठीक है. नाउ ए सेंड्स एन ईमेल टू बी offering to sell his laptop for rupees 45,000. Now the email is delivered to B's inbox at 10 a.m. but B opens and reads the email only at 4 p.m. Before 4 p.m. B had no knowledge of the offer. So when is the communication of proposal complete in this situation? Communication of offer या communication of proposal कब complete माना जाएगा यहाँ पर? तो देखो फैक्ट्स ने खुद क्लियरली बता दिया हमें कि ईमेल भले ही 10 बजे इनबॉक्स में आ गया था बट ही डिड नॉट रीड इट बिफोर 4 p.m. and before that time he had no knowledge of the communication of the offer, and therefore the communication of offer will be considered as complete when that is at 4 p.m. when B opened and read the email. ठीक है. So the correct answer in question number 23 was option B. ठीक. चलिए let's move to the next one. हाँ जी. Are we done with the 24th? चलो देख प्रिंसिपल क्या था हमारे पास. द प्रिंसिपल वाज एन इंडिपेंडेंट कॉन्ट्रैक्टर इज द वन हु इज एम्प्लॉयड टू डू सम वर्क फॉर हिज एम्प्लॉयर. He is engaged under a contract for services. He undertakes to produce a given result, and in the actual execution of the work, he is not under the direct control or directions of his employer. He may use his own discretion in execution of the work assigned, and in general, an employer is not liable for the torts or wrongful acts of the independent contractor. However, the employer may be held liable if he directs the independent contractor to do some careless act. So the principle was primarily related to the concept of vicarious liability. And the rule of vicarious liability simply says that if an employee commits a wrongful act, then the employer is responsible. But when it comes to the independent contractor, wherein you are hiring the services of an independent contractor, therein, as a general rule, you will not be held responsible for the wrongful acts of the independent contractor. Let's say you hired a cab and the cab driver meets with an accident. Are you responsible? Can you be held responsible in that situation? Answer is no. Okay. So as a general rule, the employer will not be held responsible for the wrongful acts of the independent contractor, but wherein employer directs the independent contractor to perform an act carelessly, in those situations, the employer can be held responsible. Okay. So this was the principle given to us. Let's look at the factual situation. So A owns a popular cafe and hires B, an independent interior designer, to renovate the cafe and make it Instagram friendly before its reopening. B is free to choose the design, workers, material, and method of execution. Now, while fixing a neon sign near the entrance, B carelessly leaves loose electric wires exposed. A customer P touches the wire and suffers an electric shock, and P sues A for the injury caused due to B's careless work. Decide. Is A responsible in this situation? The answer should be no. क्योंकि अगर केयरलेस वाली सिचुएशन में चलो हमें अगर लेके भी जाना है तो क्या ए ने डायरेक्ट किया था उस इंडिपेंडेंट कॉन्ट्रैक्टर को कि आप केयरलेसली काम करो? नहीं ना. मोर ओवर बी वॉज एन इंडिपेंडेंट कॉन्ट्रैक्टर एंड देयरफॉर एज अ जनरल रूल ऑफ लॉ the employer cannot be held responsible for the negligent or the wrongful acts of the independent contractor, and therefore the correct answer was that A is not liable. A is not liable because B was an independent contractor and A did not control the manner of the execution of the work. Okay, so the correct answer over here was option B. Chalo, let's look at the last question of the day. 25th question solve kar. Done, everyone? Chalo, dekho. Let's look at the question. So the principle was whoever takes away any movable thing from the land of any person without that person's consent, he's said to make or he's said to have committed theft. So if you are moving a property outside the possession of a person without that person's consent, that amounts to theft. Okay? Now, facts were that during his visit to house of C, A saw C's pet dog wearing a smart GPS collar, and A asked B, the younger son of C, to bring the dog outside so that they could take it to a nearby park for making a short social media reel. Neither A nor B informed C or took his permission. B brought the dog outside and accompanied A to the park. Decide. Whether A can be held responsible for theft in this situation, the answer will be yes. Why? Even though it was accompanied by the son of C, but did they take the permission of C to move that property outside the land? No, right? And therefore the correct answer was that A has committed theft because the dog was taken away from C's possession without C's consent. Okay? So the correct answer in this question number 25 was option C. ठीक, चलो अब देखो NLUO के पॉइंट ऑफ व्यू से ना कुछ चीजें अपनी अच्छे से प्रिपेयर करके रखना. ठीक है? प्रिपेयर द कॉन्स्टिट्यूशन ऑफ इंडिया और रिवाइज द कॉन्स्टिट्यूशन ऑफ इंडिया, दैट इज द स्टैटिक पोर्शन. ठीक है? स्टैटिक पोर्शन ऑफ द पॉलिटी properly. You can expect the questions from this portion, and at the same point of time do cover your legal terms and maxims. प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस अगर आए भी तो बहुत ज्यादा क्वेश्चंस आने की एक्सपेक्टेशन नहीं है। 2 या 3 या 4 या ज्यादा से ज्यादा एक दो क्वेश्चंस आप प्रिंसिपल फैक्ट बेस्ड आप एक्सपेक्ट कर सकते हो इन योर पेपर। बट दीज टू थिंग्स, majority of the questions of a kind of a legal topic are primarily related to these two portions only. तो इन दोनों को प्रॉपरली रीड करके रख लें, जैसे हिस्टोरिकल बैकग्राउंड ऑफ द कॉन्स्टिट्यूशन, मेकिंग ऑफ द कॉन्स्टिट्यूशन, फंडामेंटल राइट्स, प्रीएम्बल, डीपीएसपी, प्रोविजंस रिलेटेड टू द सुप्रीम कोर्ट, हाई कोर्ट, normal things ki where is a particular high court located, when was the particular high court established, and so on and so forth. ठीक है, ये सारी चीजें थोड़ा अच्छे से रीड करके आप लोग रख लेना, दैट इज समथिंग इट इज इंपॉर्टेंट फ्रॉम द पॉइंट ऑफ व्यू ऑफ द पेपर। रेस्ट आज के लिए इतना ही, ठीक है। सेशन अच्छा लगा हो तो डू लाइक द सेशन एज वेल, एंड इन केस इफ यू हैव एनी रिक्वायरमेंट सो यू कैन लेट अस नो इन द चैट बॉक्स और द कमेंट सेक्शन एज वेल। बाकी तबीयत वगैरह का ध्यान रखिए, आराम से पढ़ाई करिए, एंड आई सी यू सून। All right. Thank you so much, everyone. Thank you so much, guys. Thank you so much. Thank you.